of the slide deck there. Presenters will address questions at the end of the webinar. But if you do have a technical question, feel free to reach out directly to me via private chat or in the general chat window. Without further ado, I'll hand it over to your moderator and presenter for the day, Julia Finocchi.
Good afternoon, everyone. Thank you for taking the time out of your busy day to join us. We're happy you're here. Just a little housekeeping. We will take questions at the end of the presentation. Please hold them or jot them down in the chat box, and we will address them at the end of the presentation. I am happy today to be joined by my colleague in all things GDPR, Mark McConaughey. Mark?
Well, thanks, Julia. And hey, before we get started, I do have a question for everyone out there. Again, thanks for all of you joining us today. But, I don't know about all of you, but if you would all just raise your hand if in the evening, just a little bit, you all enjoy just a little drink now and then. Well, of course, this is a webinar, and I really can't see your hands, but pay no attention to that. But what I would say is, each night, just to relax a little bit, I do have just a slight taste, maybe even just half a bit of Irish whiskey, really good Irish whiskey, just to let me relax. All those other drinks I have are really because of the GDPR. So I'm glad Julia's here to try and help us out and move us forward as we think about how we're going to respond to the European Union's General Data Protection Regulation. And back to you, Julia.
Okay, and before we start, with drinks or no drinks, there is a disclaimer in all of this, and that is seen on this first slide here, to say that we are not lawyers, Mark or I, thank goodness. And therefore, anything we say, this is really just our opinions and not legal advice. So,
Hear, hear.
So, I do not see the slides up here right now. Are you all seeing them?
Yeah, we are, Julie, and we're on the disclaimer slide.
Great. Okay, moving on to the next one. Our agenda today is fairly brief. We're going to go over implementation, and we're talking about the overview and the basics of GDPR, because before we start, we always just need to talk about that just a little bit to give the background for anybody who may not be up to date on that. Then we're going to talk about an interassociational guide that we've published and how we approach that guide and what can be found in that guide. At the very end of that, we'll talk about one institution's approach or an institution's possible approach to the GDPR.
Okay. Charles is going to head over right now. Oops.
Okay.
Hey,
so,
and one thing I would add, and I think it's worth saying right here at the very beginning, we did go through this process of creating the interassociational guide. And I will say this again as we get down to the institution's process, but it's worth knowing that there's precious little guidance coming out of either the EU or those of us in the U.S. who have to deal with the GDPR. And thus, it really is kind of a wild, wild west of interpretation. I will say that again and again. I will say it again as we get to specific instances and so forth, that really, and I think Julia will back me up, there just isn't a template out there for how we're supposed to respond to this potential regulation.
that's correct. And a lot of what we did at the beginning, early on with this, was to, after implementation, to think about what was happening and to see what kind of news we heard coming out of the EU. And it has been very quiet as far as follow-up. So we're all sort of waiting to see how this might be kind of brought into what's next. But we're still waiting to see. With that, I would say first, implementation occurred on May 25th, 2018. I happened to be in Europe on that day, and I looked around, and as May 25th came, nothing seemed to change right in front of me. However, the GDPR does signal really a new era of data protection and privacy. It's important to understand with the GDPR and with the European view that data privacy is a fundamental right and cannot easily be bargained away. Okay? That is something a little bit different than how we think of our data protection and data privacy rights. So it's a little bit different cultural thinking about things. Also, there must be a lawful basis for all data processing. And that lawful basis would include things such as consent, that processing is necessary to perform a contract, or it's required by law, a legitimate interest. So that has to be balanced against what the individual is trying to achieve with sharing their data and taking and controlling the data from the data controller's perspective.
You know, Julia, if I could add, I think the concept of lawful basis, especially after I've gone through a specific institution's review of the GDPR, understanding what lawful basis is, understanding when and how consent is required for doing specific kinds of processes, and when you can invoke some of the other aspects of legal basis, like legitimate interest. There are several others. Understanding those, I think, is one of the primary things you need to do as you go through with your general understanding and review of the GDPR. Sorry to interrupt, Julia.
That's all right. Okay, so your personal data processing is subject to principles. And this next slide really tells us about those principles. And the first one being transparency, lawfulness, and fairness. And really what that's saying is pretty much what it says. And then purpose limitation. The purpose for your processing needs to be clear, and it needs to be for that purpose only. Data minimization. This is really saying that the adequate, relevant, and limited to what is necessary in relation to the purpose for which they are processed. That's data minimization. So is it adequate, relevant, and limited to what is necessary? Data minimization. Accuracy. In other words, accurate and where necessary, the data must be kept up to date. Every reasonable step must be taken to ensure that personal data that are inaccurate or having regard to the purposes for which they are processed are erased or rectified without delay. That's that right to rectification. Storage limitation. Storage limitation really means it has to be kept in a form which permits identification of data subjects for no longer than is absolutely necessary for the purposes for which the personal data are processed. Okay? Data could be stored for longer, but there are certain limitations around it. There are certain conditions surrounding that storage. Security. Data has to be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage of the data. And finally, accountability. The controller shall be responsible for and be able to demonstrate compliance with the above principles. So these are principles that are explicitly laid out by the GDPR. You can find all of these principles and an explanation for them in Article 5 of the GDPR, as well as the Recital 39. And that really explains to you what the principles are that are required.
And I would say, just as a general thing, Julia, that, you know, in very many ways, these are not unique or different from our domestic privacy and security laws now. The idea that the information we have under FERPA needs to be available to those for whom we're keeping records, that's already something we're pretty accustomed to doing, and doing things like lawfulness and fairness and accountability and ensuring the accuracy of the records. I will say that, you know, as big and profound sometimes as the GDPR sounds, it's not as scary as you think, particularly in terms of these basic principles.
Right.
It's something we're already accustomed to doing.
Right. Exactly. So who does it actually apply to? This goes to our next slide, which is territorial scope. So the GDPR, and this is stated, applies to processing carried out in the EU. It applies to organizations outside of the EU that offer goods and services to EU residents. and it applies to organizations outside of the EU that monitor the behavior of EU residents. Pay attention to that word residents. It is not citizens, it's residents. So any organization that monitors the behavior of EU residents, such as tracking their online behavior, the GDPR says it does apply to those entities. Obligations of the GDPR, though, are tied specifically to whether an organization is a controller or a processor. Okay? A controller, and this, just think of it this way, it simplifies it a bit, is the entity that determines the purposes and means of the processing of that personal data. Okay? A processor, on the other hand, is an entity that processes personal data only on behalf of or on the instructions of the controller. Okay? So a lot of times our vendors, our third-party vendors, would be the processors, whereas we would be the controllers of that data.
And you know, Julia, a couple things to say, and this just goes to show you the Wild West nature of the interpretations of the GDPR. We were very, very clear. We had a large group of us, including a couple of independent lawyers who were part of our group that created the Interassociation Guide. We had NACWA, which is the Professional Association of University Councils. And thus, this really is how, when we took a look at and interpreted the various provisions of the GDPR, this slide really summarizes it really, really well. However, I was just at Technology Transfer Conference over the weekend and heard from several vendors who were taking a look at how they interpreted the GDPR, and they really felt that it wasn't where, in fact, the data was processed or where the data subject might reside, but rather it was just EU citizens and those who were perhaps in the territory of the CU for whom these GDPR provisions apply. Now again, Julia and I and those who put together the Interassociation Guide really do stand behind what we believe the GDPR means, but what I will say is, man, there is not a universal truth for how the GDPR is being interpreted by those who are subject to its provisions. That is just a fact at the moment.
That's so true, Mark, and we absolutely did see that. We talked to several people at Tech and Transfer who very much were thinking they had it understood and then engaged in conversations or in discussions with vendors or potential controllers and found that the interpretation was very different across the other side of the table. So, but I would say that for universities, some of the ways that universities see that this might apply to them are universities with their own branch campus or study center in the EU, online learning platforms, research incorporating EU data sets. So there's a lot of ways that it could be interpreted as absolutely applying.
And I think this is also a very important slide that Julia put together here, understanding when we go through some of the actions and things we have to do under the provisions of the GDPR. One of the things is to make important notes of your connections with vendors. And in order to make the appropriate connections with vendors, you really have to understand what controller and processor are, and that relationship, the definition, and define your role. Understanding that will lead your institution and assist in going a long way toward how you're going to interact and what actions you're going to take, both in your own personal systems and how you interact with your service provider. So I think it's just very, very important. One last thing I would say, and I thought this was an important part as our own institution sort of went through this, is there's really a third category, and the third category is not only you may deal with a service provider in which you are not the processor of information, either as a controller or as a processor, but quite frankly, you're the recipient of that information. So then the question becomes just what are your obligations if you're simply a recipient, a customer, or a consumer of that information? It isn't expressly given there. You assume there are responsibilities by those who provide it to you. But that is, in fact, you need to recognize that as a category of a relationship.
Yeah. So in thinking about all these things and in trying to get our own heads around GDPR, we decided that maybe we had some colleagues who are also wrestling with this issue. And indeed we did. So we put together a working group, an informal working group that looked at the GDPR and started discussing it. And what we came up with was that we wanted to ultimately provide an interassociational guide that really addressed what were the implications of the General Data Protection Regulation. And the charge of that group was to raise awareness, to inform and explain to our association members the General Data Protection Regulation, and to provide background and an explanation of the provisions of the GDPR as a foundation for conducting a risk assessment, and generally to assist those institutions in preparing their response. So that was really what we kept at the forefront of our minds in trying to build this, because even in the awareness and starting to understand the GDPR, the implications for how you took that regulation and then looked at that regulation in your institution and how you were going to even begin to tackle complying with the GDPR. So we had participants for that guide from ACRO, Mark from Indiana University Bloomington, from CASE, EDUCAUSE, the National Student Clearinghouse, NAFSA, NACAC, NAFPA, and it really was an excellent opportunity for us to sort of discuss the similar needs we had to inform and support our members on this. Our approach for the guide was actually fairly straightforward. We first decided we needed to reach some agreement on what the primary provisions of interest were to the group. And that was actually a bit easier than it even sounds, because we did have many of the similar concerns for our members. And then we worked to develop information processing scenarios, exercises that would test the GDPR provisions in a higher education context. Because while there was information out there from a business perspective and from other perspectives, and while there was Privacy Shield that was available for corporations to use, the higher education framework and context was a little bit more vague. We didn't have the guidance that we were hoping we would have. So we were trying to figure out how to take these provisions and really look at our situation as higher education institutions, our members being at higher education institutions, and how they could test and then apply sort of processes, business modification processes in considering the GDPR. So we provided a discussion of roles, considerations, and potential institutional responses to those provisions. The next slide really shows you what the content of the guide is. So it begins with the background of the GDPR and sort of a risk assessment and first steps, along with a set of guiding questions that an institution can ask itself in beginning to think about how to go about this process. Then those recurring considerations for responding to the GDPR provisions. And then really, I think one of the most useful parts of the guide are the sample case scenarios. And those sample case scenarios were representative of the associations that were part of this group. So we have admissions and admissions operations scenarios, enrollment, reporting, verification, and data analytics services from the National Student Clearinghouse. There's a whole section from them. Also, study and education abroad. Certainly this was something NAFSA worked a lot on, as well as scheduling, enrollment, and vising, and the right to be forgotten, which seems to be the right that everybody has the most concerns about when they talk about the GDPR. And finally, we give a list of resources that members can use to find more information and more specifics and going more into depth on certain topics. So we hope that this guide has been something that institutions have found useful and can use even in the days ahead to start approaching how do we look at our institution and where we are in the GDPR process. Then we suggest some institutional first steps. And I'm going to turn it over to Mark here because he can talk to you a little bit about, from an institutional perspective, what those first steps would be. Mark?
Right, and I'm going to, I'll at first go back and talk a little bit about the guide once again. From talking to folks again at Tech Transfer when we also did a GDPR session there. And we discussed the Interassociation guide, and one of the things we did get out of that was that the most important aspect of the guide is the sample case scenarios. Truly, you can go to a lot of places and get background on the GDPR, lots of discussion about what the provisions are, what they do, what they mean, but trying to come to grips with exactly what kind of business we perform, how to step that out, how to take the provisions of the GDPR and apply them in these data workflows that we work with every day. I think having that laid out, and basically we had so many contributors who helped us put those case studies together, I think that had real value, and I think that we got some positive comments from that. I do want to say too, and I'm going to reiterate, probably a more basic way of saying it is I'm going to repeat myself as I start into what an institution might do. I am reminded of a Groucho Marx saying, and that saying is, these are my principles, and if you don't like them, I have others. And thus, we're going to go through a particular fictional Midwest institution's interpretation of the GDPR. And as many of you guys know out there, I like to refer to myself as Brad Pitt, and if ever I was going to pick someone to play a registrar who would be me, it would certainly be Brad Pitt, because I think there is such a commanding resemblance. Now, of course, this is an audio webinar, and you can't verify that one way or the other, and the picture I throw up there could be anybody. So it's really up to you to consider whether that's the case or not, but nevertheless, this is a fictional university set in the Midwest with a bright, young, handsome registrar who has become part of this GDPR working group. And the first thing that happened to Brad Pitt is that he got a call from University Counsel. And he said, there's this thing going on in Europe. They're worried about digital security and privacy. And as a result, we've got to figure out just exactly what our beautiful institution here set in the Midwest is going to do about it. Now, the first thing the University Council did is he formed an EU GDPR working group. You can see on the slide the various areas that were included in the working group. And I will say that at this particular Midwestern campus, and I can see that finally a real picture of me showed up on the webinar, that the University Council got this together, and I'm really very pleased that that happened. We did put together that working group, and then included, and it's one of the things that's mentioned in the GDPR, is that you really should have a security officer, someone who takes direct responsibility for all aspects of digital security and privacy. You have to include, of course, those in university technology or information technology, and of course, folks like me who are responsible for the operational data processing of the information. Now, one of the things I would say is that the University Council really had to take into account all aspects of all the information that we process. In other words, that would include faculty records, research information, human resources information, all kinds of other areas. Now, both for the Interassociation Guide and for what I'm going to talk about as we move along through this webinar, is strictly focused on the recruiting of students, or really the student life cycle. It is the recruitment, enrollment, and then post-enrollment. So that's where we're going to head with this. So once you put together this group, one of the things that you think of when you say put together this group is that you're all going to get together in this big meeting room and hash it all out. Well, that isn't actually the way that at least some places have performed this task. In fact, the University Council, with some sort of organization and structure, reached out to the various processing units and basically said, hey, we have to take into account this new privacy set of regulations and laws. We need to know from your perspective and for the kinds of business that you operate and administer, what are the kinds of things that you care about? How can we identify how these specific provisions are going to apply the kind of work that you do? And so that's really what happened. We ended up, and I think the University Council had many types of meetings of this ilk with the various stakeholders on campus, and he most certainly had one with the Brad Pitt of registrars here on this Midwestern campus. And so when we did that, one of the ways that we decided to do it was exactly as the Interassociation Guide suggested, which is take a look at the various data processes that you have and start providing the data processing workflows. In other words, start identifying what happens to the data. From where did the data emanate? Where did you store it? How did you process it? What service providers and outsourced components did you have? What was your relationship with those components? What kind of actions did you take once you had communicated with the various units? What kinds of information do you need to keep? From the idea of the overall group, each group was supposed to perform these kinds of analyses. Once you perform the analyses, then from the group's point of view and from University Council's point of view, you can begin to identify those kinds of pieces that begin to align. In other words, where were notifications required? Where were specific kinds of data processes like deleting sets of records? Where were data life cycles really important? When you begin to do those things, you can align them all, and then from an institutional perspective, begin to determine what kind of development projects are required in order to comply. And you can achieve a little bit of economy of scale as a result if you know that HR needs to do this, student records needs to do this, and faculty records needs to do this. Since all of these pieces align, we can achieve a little better economies if we go about it this way. And of course, I would also say, one of the things you have to do when you take this into account is consider scale. What is your risk? What are the mitigating factors that you can do? Is it necessary to take, if your scale is small, is it possible for you to treat those as exceptions and deal with those exceptions manually rather than making systematic changes to your systems in order to accommodate the privacy changes? Now, one of the things I would say, and I think it's a recurring thing both from the Interassociation Guide, and it was also part of this Midwestern University's process, was that it was very, very important to perform this analysis and do due diligence in writing down how you were going to treat all of these aspects and what actions you were going to take as a result. Since there is no overall guidance, since there is no right or wrong, since I have a set of principles, and if you don't like them, I can have another set of principles, you need to define what your set of principles with regard to the GDPR, and basically ensure that you write down what your institution is going to do as a result of doing that. In other words, do due diligence, write it down. It doesn't mean that you need to publish it. It simply means that you, if challenged by someone, either in the by a data subject of the European Union or by whomever, that in fact you've analyzed and you are responsive to the provisions of the GDPR. You've taken and written down the possible ways you're going to respond to it, and in fact, your institution implemented and did exactly what you wrote down. If you do those things, I believe they may come back and say, well, you know what? Your interpretation is simply incorrect. However, you took it seriously, and although I'm not a lawyer and I can't provide legal advice, my opinion and the opinion of those of others who've discussed this is that if you take all those steps, in fact, when you do it, if you're challenged, I think if you're, whatever penalties and findings may be, will be minimized. They'll simply say, you know what, your interpretation is not really what we had in mind. Here is how we interpret it. Please put these actions into place. That's certainly our hope, and that's certainly how we're going to approach it.
I would just underscore that, Mark. I mean, I think that if you take nothing else from all the webinars that we've done, it's to take that. Document your approach. Document what you've done, because I think that is the most important thing you can do to really protect your institution and to know what it is that you're doing. I mean, it's essential that you have that document.
Yeah, I think the position you don't want to be in is as everybody stopped at a stoplight, and all of a sudden the light goes from red to green, and so May 25th was red to green, and all of a sudden you get challenged by the honking horn behind you, and it turns out you haven't done anything. You're not ready to push the gas pedal. You're now just standing in traffic, and if somebody comes to the institution and says, gee, I really wish to be forgotten, and you have not done anything about taking care of these things, those findings may be quite different than if you left that intersection in plenty of time. And in fact, if challenged, you say, well, of course I did. I had everything lined up. I knew exactly what I was doing. I was staying in traffic. Oh, I was going the wrong way. Well, that was because the map I had was the wrong one. So I just can't emphasize that enough. Do the due diligence, write the due diligence down, and then act on your due diligence. And so here we go. Now we've had the student records in the EU GDPR, and of course I've talked about the group. And what I'm going to talk about now is, in essence, at least for the rest of this webinar, is really the kinds of things that we considered as we went through the student life cycle. The student life cycle primarily, and for the purposes of the GDPR discussion, really had three primary areas. They really were admissions and recruitment. That was one, and think of it as the admissions funnel. You can't see me moving my hands, but trust me, I'm making the shape of a funnel as I stand here and talk to you all. Number two is enrolled students. So what happens once we've yielded them and put them in our systems and they are consuming our instructional services? That's a second whole group. And last but not least, we've gotten success. These students have successfully gone through our pipeline. They've graduated, and now they move into the development world, our foundation world. This is the postgraduate world. And those are the three primary areas. And I think they represent three different kinds of considerations for the purposes of the GDPR. I might add, before I move on into really a little deeper discussion of admissions, that in the world of enrolled students, there really are three subcategories. And for the purpose of this Midwestern University, we considered three things. One, they are enrolled students who reside domestically. In other words, they are consuming our instructional services on United States soil and thus look very similar to domestic students, at least from that perspective. Number two is online enrolled students. In other words, online enrolled students can be consuming our instructional service from almost anywhere in the world, including data subjects who fall under the territoriality of the GDPR. That's number two. And number three, what about students who are basically students of our own institution, but they travel overseas for overseas study? We have consortial relationships with institutions in the European Union. What happens to record keeping and our responsibilities as students reside and are taking classes in those institutions? So those are the three primary areas I'm going to discuss. So let's talk about this Midwestern institution. One of the first things you have to do as you consider the funnel and the various aspects is, well, gee, I wonder how many potential GDPR data subjects we might have at any given time in our data processing flows. So consider the admissions funnel here in any given year. This fictional Midwestern University has approximately 5,000 students, potential students, suspects, prospects, whatever you want to call them, who potentially are EU data subjects. And by data subjects, it's always the word used, meaning that they are subject to the provisions of the GDPR. Now, how might you determine that they are, in fact, potential data subjects under the GDPR? And for one of the easiest ways to do that is to simply use their home address, however you've defined home address. recognize that using the home address may not be 100% accurate, but for the point of view of determining very quickly and easily who might be data subjects under the EU, this seemed like a very easy and probably an appropriate thing to do. Recognizing it, the fidelity of it probably isn't complete, but it's probably good enough, or at least for the moment. So for us, the Midwest University, 5,000 students in the recruiting cycle. We get of those, we get approximately 500 who are admitted. In any given year of those, we get about 75 who actually yield and come to the university. In a given year, we have about 500 EU students enrolled, and of those, about 120 graduate each year. So that gives you an idea of the various categories of the students we need to pay attention to. So let's talk about admissions and recruitment. So what happens? You know, there's an aspect of the GDPR where we talk about the following, and we're really, now the first thing to consider is, all right, I'm gonna recruit members, I'm gonna recruit persons who are, we believe are data subjects or who are potentially data subjects from the GDPR. What constitutes them being a data subject? And there really are two things. The first one is goods and services. And do you actively offer goods and services within the confines of the European Union? And you start thinking about that. And I do this in some detail just to give you an idea of the kind of analysis you might do at your own institution. Well, you know, we do offer goods and services per se, but we don't actively do it. We don't put up a website in Germany or in Spain, and we don't actively go out and recruit or have ads or target specific populations within those areas. We don't change the language. In other words, we don't have Spanish versions of what we have that go out. We don't have German issues of what we go out. So in that sense, just because we have a web page up and someone from the European Union, from Germany or from Spain, happens to interact with our website, the Midwest University here doesn't believe that that is offering a good and service. In fact, from that perspective, the student has entered into a relationship with this specific website and seeks to consume the services of the website that's been put up, in this case, the Midwest institution. Now, let's say that that happens. So from that point of view, we're free and clear. We don't think the GDPR applies. However, now that I've gotten that name, that suspect, that prospect, what happens when I take that and I start using a service like Slate or Salesforce to track what I'm doing as I go out and try and recruit this individual student? That is digitally tracking their behavior. So in other words, I take a campaign, I send them out an initial notification, I determine as they open that, let's say it's an email notification, if they click on things, and I start tracking those clicks, all of a sudden, I really am tracking their digital behavior. Now, in that sense, I think that's another important consideration, and I'm sort of moving through what I've already done, but, you know, in this case, from the point of view of recruiting that particular group, they are data subjects of the GDPR. So I already told you, now, if we decide that we're going to do that, do I need to track that, in fact, I have decided that they are going to be GDPR data subjects? And probably we'll have to figure out how to do that, whether I'm going to do that with just the maintenance of the address. Is that sufficient? Or do I need a specific attribute so that I know what happens to them over time? In other words, I need to maintain state about whether they're a GDPR data subject or whether they might evolve into not being a GDPR data subject if their status changes. And if so, I need to take other considerations. If I do decide they're a GDPR data subject, what kind of actions do I need to take? What kind of notification do I need to send? And I know that all of you, since May 25th have probably received dozens, if not more, data privacy notices from the various services that you use online And all of these have been as a result of them trying to be compliant or trying to comply with the GDPR. And then last but not least, I need to consider whether or not, if indeed we've decided that they are GDPR data subjects, what kinds of actions I can take and whether or not I can be compliant should that particular data subject request, for example, to be forgotten or not be processed in a particular way. So I think I've already tipped the scales. I already said that since we do digital tracking at this particular Midwest university, we believe that those 5,000 or so data subjects really are subjects to its provisions. As a result, what actions are we going to take? Well, I think one reasonable way to interpret that policy is they've come to us, and I might also say, so how do we get them? And this is where you start thinking about your relationships with service providers. Often we receive them either from testing services or we buy their names from some other service. In other words, and those populate our prospect lists, and we deal with those appropriately. Well, what's your relationship with that particular vendor? And that's where I talked about before. There really are three kinds of roles. There's controller, processor, and in this case, they have a controlling process. Maybe it's the testing vendor. We really knew nothing about it. But we received this information from an outside vendor who was saying, this particular student, this particular potential student has interest in your institution. We must assume, unless I've reached out or they've reached out to us, we must assume that they have been compliant with the GDPR. And certainly I don't think there's any liability associated with us receiving that information, per se. Now, once we've received the information, and we take action upon it, again, that's where I think we have to analyze and say, we believe this person is GDPR. Now we're going to send out a notification. If I'm using a CRM, and that's an off-site CRM, I now have I'm now the controller of that information, and I have a relationship with a service provider who is a processor of that information, assuming that the CRM is cloud-based. So now I have certain responsibilities that I have to carry through. Where I was headed with that is that now I've got this information. I recognize, or at least my institution says that they are a GDPR data subject, and the first thing I do when I reach out to them is let them know that for the purposes of what we're doing, here's your privacy notice. Here's what we're going to do with your information as we try and recruit you and yield you to come to this Midwestern university. So that's a whole bit. If, in fact, I use that kind of relationship with a CRM, I really have to understand my working agreements. And it's worth it to say, just on the side, I know that if you use Salesforce or something like that, Salesforce is all over this. I'm not plugging Salesforce. I'm simply saying they really do have, they were on top of the GDPR. They have good privacy notice. They have good working relationships with all of their clients, probably because of scale. But I do know that that's the case. If you're using some other form of CRM, you may want to take a look and see what your particular processor, what your particular vendor has done. And the last but not least is that, the provisions of the GDPR are not, they don't grandfather in. Now, that's subject to some interpretation too, but this Midwestern University basically decided, well, May 25th, our recruiting for the 2018-2019 academic year is nearly complete. And as a result, we're really not going to move forward and do anything with our 2018 year. We're going to put all of these things in place for the recruitment of the 2019-2020 academic year. So those are some interpretations. I repeat, these are interpretations. Your interpretation may be much, much different. And in fact, even some of the vendors I've talked to are much, much different. But this is one interpretation. And as long, again, I'm going to go back to the due diligence piece. As long as you write it down and do what you say you're going to do, I believe, although I can't guarantee it, I believe you'd be in pretty good shape. So what about enrolled students? Well, here's an interesting take. Once a student was in the EU, He's recruited. He's going to come to the Midwest and consume all of his instruction from the institution within the United States. One interpretation of the GDPR is that once they arrive in the States and consume all of the service domestically, they are no longer subject to the provisions of the GDPR. That's at least one interpretation. There's another one that says, and I'll give that one too, that, one of the ways of interpreting the provisions is that any data collected while the data subject was inhabiting a territory within the EU, then they still must be subject to the provisions of it forever and ever and ever. At least for this Midwestern university, I don't think we're going to at least initially do that. We're basically going to say the preponderance of everything they're doing once they arrive domestically and start consuming our services happens within the United States of America, and they're thus subject to the provisions of the United States Privacy Acts. So as a result, that is one whole consideration. Now, of course, so doing, you can see where, as I talked about, the admissions component, when they come down through the admissions funnel and now they're enrolled, there's a change of state. They were once subject to the GDPR and now they're not subject to the provisions of the GDPR. We can worry a little bit about exactly when that happens and where the threshold is, where that state changes. But doing exactly that, I'm not sure exactly where that state might change. It could be when they arrive in the U.S. It could be when they enroll. But there are various milestones that you can use in order to do that. So that's really it. And so if you think about that specific designation, then quite frankly, many things that you would worry about with GDPR, for example, the right to be forgotten, really don't come into play. The sending information off to the student clearinghouse doesn't come into play. You get the idea. Online education, that's a slightly different aspect. Using the same thinking that I used for domestically consuming students, those in the EU who are consuming your instructional services probably do fall under the provisions of the GDPR. So then you start looking at, well, okay, now we've made the same things. You can start considering the exact same things you did when you were considering them in the admissions funnel. But it's probably worth it to take a look at scale. From at least one Midwestern university's point of view, the scale, meaning the number of students who are actually consuming our services while residing within the EU, is really pretty small. As a result of it being pretty small, we're probably going to handle all of those manually, individually identify them, contact them separately. We're not going to do massive development work on our SIS in order to accommodate such a small piece. Could be wrong. We could have taken the idea that we're just going to treat everybody this way, and that's certainly a reasonable approach. But I think if we took a look at our overall risk, the amount of risk involved, as long as we've outlined it and as long as we know what we're going to do, I believe this might be a good process. We'll still notify them. We'll do a lot of those things. We still have to pay attention, and this is probably worth thinking about, paying attention to your relationship with your service providers. There's still a controller-processor kind of relationship. If, in fact, you believe you have GDPR data subjects within your data that you're going to transmit to a processor, you've got to understand what your roles are. You've got to understand what the obligations are, what your obligations are, and exactly what your service provider's obligations are. Often they're not much. I mean, I shouldn't say that. That's too blatant of a statement. What I mean is they're usually pretty easy to understand. You need to understand that. We need to know who a GDPR data subject is, and you need to understand from the service provider that if one of their rights are invoked, you can, in fact, comply with the request. So that's really the important piece. Just one consideration, I think it's already taken care of, but it does help your thinking. You know, if we all deal with the National Student Clearinghouse. When they do enrollment verification or graduation verification, that is such a good example of them being a processor and you being the controller. You know, it's such a good service. They've aggregated. They do it on behalf of so many clients. And you really are the ones doing that. You've just proxied that service, and they're doing it for you. Now, it turns out that they also do something that's a little grayer, but it's probably in the same relationship. But let me explain. They also provide a reporting environment. The reporting environment, however, where they aggregate all this data, and the most common use is for admissions offices to find out that some of their prospects are admits they didn't yield. You want to know where they went. Well, in fact, yes, they do provide that, and one way of looking at that is that they're the controller at that point, but that's really not true. We have provided that information, and we basically allow access to that information from members of the consortia. Just understand that that's in your contract, just so you know that. And so as a result of having it in your contract, you are still the controller, they are still the processor, and it's still your responsibility to understand what's going on. And I think that's a good one to talk about. You know, we also have relationships with LMSs. And it's real clear in my head that when we collect information about instruction, in other words, the course taken, how they did in that course, we calculate certain kinds of things that are summary statistics. And we do those things, that is part of our legal basis. Defining what is your legal basis is another important aspect if you decide that you have GDPR data subjects within your realm. And then last but not least, and I'm just about to wrap up here, post-enrollment. Now, as you just heard me explain, if students were enrolled at the institution and they were consuming the services within the confines of the U.S., one interpretation is that they are not subject to the provisions of the GDPR. Well, what happens when these particular students graduate, they move into the development arm of the institution, and all of a sudden, the world of lawful and legal basis is not a contract to instruct and assess, but rather it's to make money for the institution. Does that whole legal basis change? That's something that we just have to consider. This Midwest University still has a bit of, not sure exactly which way to interpret this. However, what I would say is, as a result of saying that domestically enrolled students are not subject to the GDPR, we actually still use the exact same set of processes that are basically FERPA governed over the top of that transfer. Now, from the point of view of the development shop, in other words, the foundation or whatever development arm your campus has, it's very possible for these particular students to move from the U.S. into an EU area. So at that point, their state, their GDPR state changes, and as a result, the kinds of processes and functions that the individual development arm has to perform could be quite different and very similar to what we had to do in the admissions realm. So in conclusion, what I would say, and it's very, very important, is do your due diligence. Take the scenarios that are in the Interassociation Guide, or if you don't find those are germane to your particular campus, develop your own, analyze them, and determine what your steps are subject to the provisions of the GDPR. And as Julia mentioned, as I'll mention again, write it down. Write it down and do what you write down, so that in the event, so you are not that car sitting at the light when it turns green. By the way, I think there's a $1 billion app to be made so that if you are in that car and you happen to be looking at your phone, it texts you that the light has turned green. So we hope that you're not in that position, you've done your due diligence, and when the light turns green, which it already has in this case, you are prepared for whatever comes next.
Thank you, Mark. And you'll see on our last slide, we just have given you just a handful of selected resources, including that interassociational guide. And For a load of funds, the Helix Education link is a link where you get to actually see Mark McConaughey as an animated figure with both bow tie and sandals. So it's definitely worth the watch. You should go ahead and like that video. The other item that I put down there, the very last item, the Information Commissioner's Office in the UK. If you haven't been to this site, there is a wealth of information there and resources. In fact, if you don't find what you're looking for in the guide itself, the Interassociation guide, the ICO has a number of data protection assurance checklists. So a controller's checklist, a processor's checklist, information security checklist, etc. And that's really quite useful in just getting your head around what it is you need to think about. Okay, we do have some questions, and we have a little bit of time for some questions. I see that we actually have a couple of questions about the resident versus citizen. And Scott asked, if interaction does not trip the provisions of the GDPR, are others interpreting the definition of resident of the EU as someone on the ground there or is actually living there for some minimal period of time? And I would say this is a pretty gray area with the GDPR and interpretation. If you just look up, if you Google resident under GDPR, you'll see that there's a lot of debate and discussion about what resident actually means. It is not citizen. So the discussion becomes, is it broader? Is it more than that? Is it anybody basically in the world that has any involvement in any way with the EU? And you'll see there's not a lot of clarity on this. And I think this is one of those areas that we are looking for legal direction on what this might mean. Mark, would you like to add anything to that?
No, I think you did a perfect job.
Okay. So document for yourselves how you are interpreting resident. Okay, that's one thing I would say. If you're documenting things, document how you are interpreting the term EU resident. Next question. Many third-party vendors have a purpose statement in their contracts. Are vendors being required to put GDPR statements in contracts now as well? Once again, nobody's requiring that those vendors do that. But many times controllers are expecting this from vendors, and vendors are doing it. So you're seeing a range of what's going on in that. Mark, from your experience, what have you seen?
Yeah, and I agree with that. And I think from the service providers I've dealt with, there has actually been both cases where I've seen not only a privacy statement updated, I've also seen where our contracts have an addendum to include the provisions of the GDPR. I've also seen, and I'm actually, and I can speak from Indiana from this point of view, we have a couple for which we still have to work out what that, exactly what those contractual relationships are going to be. The important thing, again, I go back to what we've said all along, the important thing is doing your due diligence. Even if you haven't got it complete by a certain point of time, understanding that you need to, writing it down, and being in the process of trying to complete it will go a long way toward showing that your institution is responsible and attempting to be compliant.
Great, thank you.
That's advice, too. That's not legal advice.
Right, just advice.
I see there's another one over here, Julia, about how are records offices to interpret "I wish to be forgotten." And that's over in the right hand under the questions, Julia.
Okay.
That one is an interesting one, and that's when earlier in the webinar we talked about understanding your legal basis, and that really is, I think, very, very important. You know, in essence, you can think of our relationship with the student as a contract, and we're providing instruction and assessment, collection and recording and attestment. They're consuming those services, and as a result of the lawful basis for performing those particular functions, you need to put a box around what you believe those things are. So putting it very, very strictly, just because I'm getting a D in chemistry doesn't mean I have the right to be forgotten from that course, because that's part of our legal basis. On the other hand, if I'm having personal problems and I'm discussing those in emails or other digital forms with my advisor, I think that's a lot grayer. I don't know exactly whether that falls under legal basis or not. Where I believe the context of maintaining an academic record, though, I think that's pretty clear cut. So I think that right really depends upon how you interpret legal basis. Absolutely.
I think that we need to be careful. The right to be forgotten has been sort of a hot button issue, and as have the fines for GDPR. People think, oh my gosh, anybody's going to come to us and ask to be forgotten and have their grades erased. No. I think if you really read through the GDPR, the right to be forgotten is a little bit more narrow than that and needs to be read with the intent that's there. So if you have a legal contract and a legal basis for having that information, once again, I think the right to be forgotten is a little bit narrower than what sort of the hype has been about around it. There is another question. In Midwestern Example College, who is designated as the data privacy officer? It's actually the data protection officer is the DPO, and the GDPR deals with that very specifically in Article, I believe it's 37 of the GDPR, and really outlines what needs to be considered in appointing that data protection officer. Mark, what would you say that Midwestern College would say about having and appointing a data protection officer?
Well, in many institutions, there is a chief privacy officer that was associated with primarily the administration of digital privacy and security, so they deal with all things that are associated with breaches. They deal with things like FERPA requirements and FICA requirements, those kinds of things. And in fact, and I can speak with authority from Indiana University, we have a chief privacy officer. And that is between that person and university council. At least in my experience, that's been where most of this has revolved. Now, if you don't have one, and you can help me here, Julia, since I didn't have to pay much attention to that, if you don't have one, I think you need to find someone either in the IT or in the policy world who's going to take responsibility for that. It's basically someone in the institution who has taken responsibility for the digital guardianship of records.
Well, I will say that there has been discussion back and forth about whether institutions, higher ed institutions, and all institutions and entities need to actually appoint a data protection officer. So that is up for some debate, and that's absolutely something you should take to your legal counsel or to consult with an outside legal counsel on whether or not it behooves your institution to actually appoint a data protection officer.
And shall we say it again? Once you've reached a decision on how you're acting, either whether you're naming one or not, write it down.
Right. Absolutely. We have a question here. Do we need to have a signed agreement with groups such as the clearinghouse? And if so, what should be included in the agreement? Mark, I'll let you take that.
Okay. Thankfully, I think, well, let me answer the first question first. For a processor, you do need to have a bit of a written understanding about what your obligations are under the GDPR and who is doing what. So for this National Student Clearinghouse, thankfully, they are very attuned to this, to the GDPR. I believe they've already got an addendum, although I haven't verified that, but I will do that with the National Student Clearinghouse, and maybe that's something we can do. Julia, you and I can do that and reach out to the clearinghouse and see what exactly the verbiage is. They're very, very aware of it, and yes, ostensibly, if you believe you have GDPR data subjects, you do need a relationship with all of your processors knowing what will be done in the event of either a breach or some other sort of action, and how you treat various requests that emanate as a result of the GDPR. So I think the short answer is yes. I don't think it's onerous, however.
Okay. Mark, there is one other question from Cindy. It said, you mentioned earlier that admissions sends the student the privacy notice. If that is the case, why would the registrar's office also need to send it to the online student once he or she is enrolled? Not sure I'm understanding that completely.
Well, I think I do. And I kind of made that case that we really separated the world into three different units, our student life cycle into three different units: the admissions world, enrolled world, and post-enrolled world. And in the enrolled world, in the admissions world, when we send the privacy notice, we also have to include all kinds of things about what we might do in the privacy notice to try and recruit you, which might be digitally tracking various kinds of information that we may not at all do as a result of doing the kinds of business processes once you're enrolled. So I think that's the fundamental difference. The set of legal basis by which we're going to collect, process, and communicate the information is quite distinct and different in the admissions realm than it is in the enrollment realm. It's important also for just the previous question that we had, for someone who might wish to invoke the right to be forgotten, understanding what legal basis is. In other words, when someone finally enrolls at your institutions, what are they signing on for? And if they're signing on for you maintaining a permanent record, they need to know that.
Right. Okay, we have a question. What about EU residents at a U.S. institution that study abroad in the EU? And it's not clarified whether they mean the institution in the EU is a U.S. institution located in the EU or if it's an EU institution. Either way, once they go to the EU, if they're an EU resident to begin with, certainly it applies. If they are studying abroad in the EU, it would apply. As I would see the GDPR written, I would interpret that to mean an EU resident certainly has GDPR that applies. Somebody who is studying in the EU, whether or not they're a U.S. citizen or an EU citizen, it would apply.
And I agree with that, Julia. The question is, to whom does it apply? So if I'm in a consortial relationship with an institution inside the EU, certainly that institution within the EU that is providing the instruction and collecting the records is certainly subject to the GDPR. At the point in time those records are transferred back to the home institution, right. I'm not so sure it's so clear.
Right, right. I would agree with that clarification, yes. But once again, that's a legal issue that you should consult with your legal counsel.
That's right. And once you've made a decision, so if you buy the interpretation that I just stated, write it down.
Right. Okay, we have one more question that I would like to address, and that is, does anyone know how institutions of higher education in the EU are handling the GDPR? One of the things that we gleaned from the tech and transfer and from a roundtable that was done there is that this is an area where we're going to do a little bit more research. ACRA would like to look into this a little bit more for memberships of how are institutions of higher education in the EU handling the GDPR, and then to get that information back to our members, because that is one thing we have not investigated quite as much as we would like to, and to get that information back to you. Have we covered all the questions? I do see one more. Does GDPR apply to former or graduated students too? The GDPR applies from May 25th onward. So if those former or graduated students come back to you for any reason, if you're pursuing those students at all through your alumni or development office, I think in that case it would apply. Mark, would you add anything to that?
No, I think you stated it perfectly.
Okay. So we have made a commitment to you that we will look a little further into how institutions in the EU are handling the GDPR. If you have additional questions, please feel free to go to the ACRO website and to let us know. You can email me directly if you have questions, and we will keep following this for you. Thank you. We appreciate you being here. Mark, thank you as always for your lightheartedness and for your expertise in this area.
And might I say, I believe this will be the last webinar that will be broadcast from the auspicious location of One DuPont Circle.
Woohoo!
So the next one will emanate from someplace quite different.
From someplace else, down the road. Correct.
Yep, about 5 blocks. Thank you, everybody.
Thank you, everybody.
Thank you.
Thanks, Julia.
Sure, thank you.